Welcome back. Thank you very much for joining us for the third European Law interview. The interview is sponsored by the Monnet Chair on Trade and Environmental Matters, which is part of the EU Commission Training and Education Programme promoting innovating learning programs related to EU studies. We have the great opportunity today to interview Professor Nicolas de Sadeleer. Good morning, Professor. He is a professor in EU law and environmental law at Université Saint-Louis Brussels and Université Catholique de Louvain. We will briefly discuss exports and more precisely Article 35 of the TFEU today. And if you're looking for more information, you may consult his book called EU Environmental Law and the Internal Market, published by Oxford University Press. Before starting, I am going to reread Article 35 for the students, if you don't mind, Professor.
Please do it.
So Article 35 reads, quantitative restrictions on exports and all measures having equivalent effect shall be prohibited between member states. We will start with a very general question, Professor. So member states are always feeling like ruling and regulating their exports. Why are they so inclined to regulate their exports?
As a matter of fact, member states are not too inclined to limit exports. Growth is pretty much related for Benelux countries to export of products and services. Conversely, many critics take the view that member states are keener to protect domestic market, domestic production against foreign products or services. So that's the number of cases related to the application of Article 35 is really belittled in contrast to the case law on Article 34.
Can we go back to the real scope of Article 35? Can you please define the real scope of this article?
One must remind the landmark Cassis de Dijon case. In Cassis de Dijon, the Court of Justice decided that Article 34 was encompassing both distinctly applicable as well as indistinctly applicable national measures. So Cassis de Dijon is deemed to be a landmark case on the account that that the measures are not strictly speaking discriminatory measures. Indistinctly applicable measures are also likely to fall within the scope of ambit of Article 34. In sharp contrast, in Groeneveld, a case relating to the prohibition in horse meat production, and in Heubel case, a case that was related to the prohibition of night baking, the Court of Justice has been narrowing down the scope of ambit of Article 35. Article 35 can be applied in as much as there is a difference in treatment between domestic trade and export trade, and that such a difference entails a particular advantage for national production.
Okay, and to be a bit more precise, do non-discriminatory measures fall within the scope of ambit of Article 35?
As a matter of principle, Article 35 does not encompass indistinctly applicable measures. That's very clear. That being said, in accordance with the Groeneveld case law, de jure, so formal and discriminatory measures, do fall within the scope of ambit of that provision. And in accordance with the 2008 Gijsbrechts case law, de facto measures impacting upon foreign productions do fall also within the scope of ambit of Article 35.
So it is a quite narrow interpretation. And what is the risk to include non-discriminatory measures within the scope of ambit of Article 35?
Firstly, as I already stressed, the Court of Justice is aware that the member states are not inclined to limit their exports, are much more inclined to protect domestic production. Secondly, the Court of Justice is afraid to open the floodgates of litigation, to be submerged by a number of cases that have nothing to do whatsoever with free movement of goods and that will tend to deregulate national protective regulations. And that would be detrimental to health protection or to consumer protection or even to environmental protection.
Do you have a concrete example?
Well, let's imagine that under the listed installation policy, the plants can operate their production in accordance with a number of safety standards that do reduce the number of chemicals that are likely to be used in the course of the production. In so doing, the national authorities regulating the plant's operations do limit the possibility for the producer to compete on foreign markets in limiting the number of substances that are likely to be used within the plant. So the extension of the Cassis de Dijon to such operation will entail huge risks to maintain list installations policies.
Well, so there is a risk of dual charge for the exporter.
Yes, likely so. In the field of taxes, exporters do face domestic charges as well as foreign charges, so dual imposition is not prohibited under EU law. Likely, with respect to export of goods, some producers are likely to face domestic requirements as well as additional export requirements.
We didn't mention a very important element, waste. Can you please tell me why member states are so inclined to regulate waste exports?
Well, first one should bear in mind that the area of waste management has been preempted by nearly 20 directives and a few regulations on waste. In accordance with the waste shipment regulation, as well with the framework directive on waste management, the member states are called on to apply a principle of proximity as well as a self-sufficiency principle. According to these two principles, waste are not deemed to circulate so freely across the continent. So they are subject to restrictions. They have to be discarded or to be treated in a nearby waste treatment plant. And every municipality, every region must do an endeavor to manage in its own right the waste which are produced within the entity. So these two waste management principles do run counter the principle of free movement of goods.
Do you have an example in the case law?
Yes, Düsseldorf is a good case in point. Düsseldorf was about the export prohibition adopted by the Dutch authorities, and in that case the export of oil filters was prohibited from Netherlands to Germany unless their treatment abroad was of a superior quality to that in Netherlands. So the economic operator bore the burden of proof to demonstrate that the quality, the level of quality of the operation in Germany was higher than the one applied in Netherlands. In accordance with the Grunwald case law, the Court of Justice took the view that there was a difference in treatment between the domestic trade in oil filters and the export trade toward Germany, and as a result, the Court of Justice took the view that such a measure was running counter Article 34.
Thank you very much. So this is the end of our third interview on European law. We started by discussing the real scope of ambit of Article 35. So we saw that non-discriminatory measures fall out of the scope of ambit and that the interpretation is much more narrow than Article 34. Then we briefly discussed dual charges and waste. We are going to discuss next week Article 36, so grounds for justification. You may find more information on the website www.tradeversusenvironment.eu. This interview was sponsored by the Monnet Chair. Thank you very much, Professor, and see you next week.